Hello, good afternoon. Thank you for that. Thank you to the Department of Justice and to the Right to Counsel Consortium for having this important conversation and this really nice, fancy forum. And also thank you to Zoe and Renee and the team who invited us and put this together. We appreciate it. I'm honored to be here. My name is Seema Gajwani. I work here in Washington, D.C. at the D.C. Office of the Attorney General. And I'm really honored to be here at the table with these three gentlemen. I know that I think this is probably the conversation that is least likely to happen, the one of prosecutors talking about why and how they value their defense attorney counterparts. But I think it's also probably one of the most important conversations to be had. So again, I'm thrilled to be here. You all have the bios of our participants in your packets and your materials, but I feel like I would be remiss without having given them a chance to speak, because each of them is really distinguished and brings incredible experience and wisdom in their field. So I'm going to ask each of you to introduce yourselves, briefly talk about your role now and how you got there, and your experience in prosecution. And then, if you would, at a pretty high level, at a principal level, speak to us about why defense counsel and effective representation is important to prosecutors. So I think we can, well, maybe we'll start with Eric Sussman from Cook County.
Sure. My name's Eric Sussman. I'm the first assistant state's attorney in Cook County. I came in under State's Attorney Kim Fox about a year ago in the aftermath of the Laquan McDonald case and all of the issues, both in terms of the violence in Chicago as well as police accountability issues that surrounded and what the former Department of Justice's inquiry into the Chicago Police Department. So as the first assistant, I oversee all of both our civil division, our criminal division, and our juvenile division. We have about 750 lawyers total in our office. We cover Chicago as well as Cook County. I think Chief Swoboda, we cover a little bit of Elgin, and they're in two different counties, if I'm not mistaken. Just a little bit about my background. I was a federal prosecutor in the U.S. Attorney's Office in Chicago for about 10 years, and then I was a defense lawyer, criminal defense, mostly white-collar criminal defense at several large law firms in Chicago for close to 10 years before being, as I told these guys, before they offered me a big pay increase, and I said, sure. Getting to the question, look, I mean, we're, as prosecutors, this was mentioned earlier, I mean, we're here, our primary goal should never be we're not trying to put people in jail, we're trying to do justice. Sometimes that does mean putting people in jail. Other times, as the judge mentioned, that means finding a way to help them in terms of to the extent they have a substance abuse issue, to the extent they have a mental health issue, all of those things come into play. But our job is to do justice, and so the role of a defense attorney, particularly a good defense attorney that is active and cares about their client, comes into play from the initial setting of bond and understanding, is this a person who is a risk of flight or a danger? And for the most part, I, as a prosecutor, am not going to be in a position to have that type of a conversation with this individual, particularly after they've asserted their right to counsel. But it goes all the way through to, if there's a sentencing phase, to understanding what does make sense for this person, what is this person's background, what's their support system that's out there to help them if they do get out there, what would a felony conviction, for example, mean for this person's ability to get a job, continue to work productively, and then all the way through to, we have a wrongful conviction integrity section where it's very much of a collaborative process with the defense where we're trying to figure out the truth. It is not an adversarial process. We are trying to determine, in many cases, from prior administrations or prior ways of policing that wouldn't be acceptable at this point in time. Was a mistake made? Do we have the wrong person? Or even at this point in time, does this conviction lack the integrity that we expect, and is it really in the interest of justice to keep this person behind bars? And when I say that, I mean in the interest of justice for the community, for everyone. So let me pass it down.
Thank you. So, Matt Hecht, Sheridan County, Ohio. Sorry, prosecuting attorney. Why don't we go to you first? Would you mind?
My name is Matt Riedel.
Oh, okay.
My name is Matt Riedel. I'm county and prosecuting attorney in Sheridan County. I've been the county attorney for, I'm in my 8th four-year term currently. I was a deputy in the office for 6 years prior to that. How I came there was a little bit circuitous because when I graduated from law school, I went into private practice and I was doing estate planning. And the state of Wyoming's public defender system was really in its infancy, and they hadn't really figured out some of the bugs. We had a sexual assault case that came up in which a woman was stabbed twice in the leg. She was sexually assaulted. Her 5-year-old daughter was sexually assaulted. And the public defender, the local public defender, had a conflict because the victim in the case was his children's babysitter. And so they really didn't have a system for resolving those conflicts in any kind of systematic way, so they went back to the old system, which was the judge took out the list of all of the attorneys that were in practice in the jurisdiction, ran his finger down the list until he came to the least experienced attorney and said, "Tag, you're it, and we're going to pay you," I think it was $20 an hour, to represent this defendant. Fortunately for me, I had a little bit of background from law school because I had a paid clerkship in the local prosecutor's office in the state where I went to law school for 3 years. And I had actually second chaired criminal trials, felony and misdemeanor jury trials before, so it wasn't totally foreign to me. My client didn't fare as well as I did in that representation. And then 6 months later, there was an opening in the prosecutor's office. We tried the case, and the prosecutor the elected prosecutor who tried the case against me called me up and asked me if I'd be interested, and I jumped at the chance. That's how I got there. I'm an active vice president in the National District Attorneys Association. I am a former president of the Wyoming County and Prosecuting Attorneys Association. I just finished last year as the chair of the criminal justice section for the ABA. And so that's, I guess, the background that I bring to the table.
Good morning. You know, when you invited us for a fireside chat, I don't know where in the hell the fireplace is, but it's interesting because I imagine to myself coming here, especially having just taken a tour of the Bourbon Trail. You all know what the Bourbon Trail is, I hope, okay? Fantastic, okay? And I'm thinking, you know, I'm going to come here, sit here with a glass of Woodford Reserve in my hand, and just talk about stuff. But I don't have my glass of Woodford. I did last night, but not this morning. And we don't have a fireplace. But it's still nice to be here with you. And I'm Matt also. In the ABA and even in NDAA, they get us confused, not really sometimes, but they call on Matt and we both stand up. But I'm Matt Heck. I'm the prosecuting attorney in Dayton, Montgomery County, Ohio, the birthplace of aviation, okay? And what's interesting is so many people, and you hear about what the duty of the prosecutor is, and if you look at what the obligations are and the ethics rules, there are special ethics rules for prosecutors. And certainly the defense lawyers know there are special rules for prosecutors, but prosecutors know there are special rules for prosecutors, and that is to do justice. And sometimes I think people think that's trite, but we don't think it's that way. I mean, I don't have the 1,000 assistants that you do in Cook County, or about that, whatever, but we have 70. And so I tell all my lawyers that that is important. Whether we do the screening process that we have through my office on all felony cases, things like that, grand jury, it's very important that we do justice and seek the truth. And it's different from any other lawyer in any other practice. The other thing I think it's important to realize is that prosecutors have really been, and I think people miss this sometimes, because we do hear, because of the press, all of the crazy things that happen sometimes on cases and prosecutors or whatever, whether it's judges, prosecutors, defense lawyers, they hear the crazy cases. But they don't hear about the thousands and thousands and thousands of cases and the things that prosecutors do, because we really have been on the forefront of things such as reentry. Joe Hines, who was the retired DA in Brooklyn, okay, on the forefront of reentry. And we look at it as a public safety issue. Diversion. My office, my predecessor, he started the first diversion program in Ohio. And this is felony diversion that we operate out of my office. And, you know, we're handling 1,200 or 1,500 cases a year to divert first-time nonviolent offenders from the justice system. And so it's things like that that we're doing that I think we got to keep sight of. And it's very important to us. We work very closely with and in Ohio, we have a robust defense system. We not only have the public defenders, like in our county, we have the county public defender that's financed not only by the county but by the state. We have a state public defender. And then we also have the appointed system, so that there are so many cases that we need public defenders for, or if there's conflicts, then they certainly go down the list, as you say, and select somebody to do it. Our judges do it a little bit differently now. Years ago, I remember, like Matt says, they'd go down the list and say, okay, who's this guy? He's going to represent this character, okay? Now, so many times, especially on very serious felony cases, they are appointing people from large law firms and saying, you have this obligation too. You have an obligation to step forward and for the good of the criminal justice system to represent this person. And you should be aware, you should be able to do it, and you should be able to prepare. And these are people who have either done criminal law in the past, maybe they've been former prosecutors who are now in the private sector, so they do things like that. So we work very closely with the public defenders and with the appointed bar, defense bar. I think not every county in Ohio has that, but our county has a very close working relationship with the lawyers, and it works out well. I'm in my 7th term as the elected prosecutor. After graduating from Georgetown Law School, I returned home and started as an assistant prosecutor, and then was elected after my predecessor retired. I'm the past president of the National District Attorneys Association, past president of our Ohio Association, and past president of the National Children's Alliance, also located here in Washington. So I hope I've answered the question. Yes. And thank you for having us.
Perfect, thank you. I think Washington could use a little bourbon. But because it's the federal government, we're lucky we even have coffee here today. Or water. I think that's thanks to American University. Okay, good. Got my shout out to American University. We do have flags and a seal, and we have each other, so we're in good shape, I think. So as I mentioned, I work for the DC Attorney General and Carl Racine, and we have exclusive jurisdiction over all juvenile prosecution and jurisdiction over a segment of the adult prosecution in the District of Columbia. But I have also been on both sides of that adversarial role. I started my career here in DC working as a public defender. And having worked on both sides with defense attorneys, with prosecutors, I know how calcified those roles can be, how antagonistic and adversarial people can be about the other side. And in a trial and on a particular case, it's not hard to see the other as the bad guy or the enemy, you know, given your interest and your client's interest or the interest of the community and public safety. So I'd like to have the three of you counter that narrative. I'd love to hear at a very micro level how relationships with public defenders or defense bar have been important in achieving justice, as we've talked about it. And we'll start with you, Mr. Riedel.
We went into the law basically knowing that we were going to be going into courtrooms or likely to go into courtrooms and to be arguing with other lawyers. And in law school, I never was thinking, oh, that person may be on the other side of me in a case. I mean, for maybe it was the crowd I ran with, but we all loved to argue with each other. Most of my friends I don't agree with, but that's the nature of the business that we chose, and I think for many of us, the nature of the business that we love. And so the idea that we're adversaries, some of my best friends are defense attorneys. That doesn't come as any, or shouldn't come as any surprise to anybody, I wouldn't think, because we're in the same business. We represent different clients, we represent different interests, but at the end of the day, we're all in the same profession, and we deal with it for the most part, I think, fairly professionally. And so, you know, I think that we also, as attorneys, have an obligation to work to try to do things that actually raise the reputation of the profession, but more importantly, the criminal justice system. And so when we see a problem going on in the system, and we might get into this a little bit later, but when we see a problem going on that diminishes the reputation and the credibility of the system, we have an obligation under our ethical rules to respond to that and to try to take action to remedy that problem within the system.
I'm going to push you a little bit on that. Why don't we talk about how the defense bar is needed in addressing systemic problems?
Well, okay. Sometimes the defense bar is the party that needs the help. We've got a problem going on right now in the state of Wyoming. We've been on an economic decline since about 2006, where there's been a steady decline in revenues coming into the state of Wyoming. Most of the prosecutors' offices in the state of Wyoming are county funded. The public defender system is state funded. As a result of those declining revenues, one of the places that gets cut most frequently has been the public defender's office. Here, about 2 years ago, the legislature cut the public defender's office yet again, and this time it meant that they were going to have to cut attorneys within the system. So they cut some of the attorneys in their offices. They cut a lot of the conflict attorneys that they had previously had to take care of the kinds of situation that I found myself in, fairly fresh out of law school, and that I described for you earlier. And so this was a problem for them. Diane Lozano, our state public defender, reached out to myself, and she reached out to State Bar Counsel Mark Gifford and asked us for our help. And so it just so happened we were having a meeting of our felony level judges in my jurisdiction, and we asked to be put on their agenda. And so the three of us went to them, explained to them the effects of what the legislature was doing on the public defender's office and what that was going to mean. The message didn't apparently get to the legislature, and they've undergone another round of cuts from the state legislature. And so Diane has asked that I again attend a meeting of, it ended up, the legislative committee that has jurisdiction over it is the Labor Committee. And so we'll be meeting with them later on this month to again talk to them about the importance of having a vibrant system, particularly for indigent defense, and the credibility that, or lack of credibility, that the system has as a result of the work that those people do. So.
Thanks. Mr. Heck, when your prosecuting attorneys go up against their opposing counsel in court, some may think it would be easier for you and your staff to get convictions if they were not as effective. Why is it that you think the defense counsel needs to be effective and zealous and well-resourced?
Well, I think we had talked about just the relationships between defense lawyers and prosecutors. I think also the other interesting thing is that we do in my office both criminal and civil and our own appeals. We do it all. But also it's interesting because my office, my civil division, actually represents the Public Defender Commission. So we're their lawyer.
We have the same situation.
And so we represent the Public Defender Commission, who appoints all the public defenders and runs the offices. And so it's just, we have a very interesting relationship there that works well. But the other thing is, I want to piggyback a little bit about what Matt was saying about you have to have a relationship with people. I don't care what it is, whether it's just in civil practice, criminal practice, working with the police, and you've got to have a relationship with them. You're not going to have that just by having one case when there may be a problem, and then there's a problem, and then that sets the stage for everything else. It just doesn't work that way. And so, you know, if there's a problem and we see it, we just pick up the phone and call, not email and all that, but we pick up the phone or meet with the public defender and say, here's the problem that we need to address, whether it's we think it's a problem from their end or they think it's a problem from our end. And I think it's relationships like this. We also have, in our county, what's called a Criminal Justice Council. And they are the stakeholders of everyone's represented, whether it's Dayton Police Chief, the sheriff, the judges, my office, public defender, lay people. And so they attend these meetings when these county commissioners, when these issues are brought up. So you really get everyone's viewpoint around the table to see if you can't not only identify the issues, but hopefully solve and resolve the issues before it becomes a problem. So hopefully that works, and it has so far.
Do you want to jump in?
Let me jump in on your first question about ways that we work with the public defender. We actually have a similar situation where we represent the public defender in civil actions. So I got a very nice email and phone call from the public defender thanking us for there had been a discrimination case where we represented them in federal court, and they were very happy with the result and how it was handled. So we have that. But in terms of on a straightforward level, we came in looking to do bond reform in Cook County, which was something that had been talked about for a while, but there really had not been any formal discussions. And so we worked with the public defender, we worked with the chief judge's office, and as a prosecutor's office, for example, we had not been taking any position on bond. So our prosecutors prior to us coming in would come in, they would read the factual proffer of what had happened, give the criminal history, and wouldn't say anything. And when we came in, changed that because we believed our prosecutors should be an active participant, and if you're not part of the solution, you're part of the problem. And so we put in a set of standards where we would be recommending I-bonds for certain people, which is a recognizance bond that's called different things in different places. We sat down with the public defender to go through kind of what circumstances we felt they and us felt would be good candidates. And the other thing that we were seeing and we had heard about for a long time, is because of the cash bail system, there were hundreds, literally probably 200 to 300 people in the Cook County Jail who needed $1,000 or less to bond out. And so rather than just kind of saying, yeah, we need to fix this, the first assistant public defender and I met in my office and we said, hey, there are 300. I mean, if we divvy these cases up, we could get through 300. And so, we would meet on a weekly basis and we would go through those people. And look, there were plenty of people who I said, this guy's in on a retail theft, no serious history, there's a $500 bond, and the public defender would say, here's the thing, that guy has a mental health issue, he is currently in a program at the jail, and while you might think this is someone you want to bond out, it's probably not in his best interest long-term to bond him out right now. So to have those discussions, I mean, it makes my job, I'm able to more effectively do justice, my prosecutors are able to, and we're able to work with the public defender in that way. And the other thing the other example I'd use, and this came up with Chief Swoboda a little bit, in Cook County, they have just started, and we're way behind New York in many of these things, but we have just started having public defenders who are assigned or available at police stations, and with the phone number for a public defender posted, and so that if someone invokes, then there can be a public defender that is available to them at the police station. I think both for a lot of the police and for some of the prosecutors, that struck them as, oh God, this is horrible. And what we tried to explain to them, and I think they understand now, is actually it can be a terrific thing for us as prosecutors and for law enforcement, because whereas otherwise you could be in the middle of an investigation of a very serious crime, someone invokes, and by the time they get counsel, it's 48 hours later at a bond hearing, and to the extent there were opportunities for that person to cooperate, to help with the investigation, to do things that were covert, or maybe even save someone's life by getting valuable information, that opportunity is not there. Whereas if there is a lawyer assigned to that person right away, then we do have the opportunity to talk to the lawyer and to say, look, here's what we need. If we can figure out situations where maybe we set up a proffer situation, maybe we do something informal in terms of a cooperation agreement, but we are able to actively work with and do a lot more in an investigation than we could if that person did not have a lawyer. So I think there are countless situations where having access to good counsel is a huge asset for prosecutors and law enforcement.
Great, thank you. So I'd like to talk briefly about what I think we're seeing nationally as a shift in prosecution and expectations for prosecutors. And I think Mr. Sussman is part of that kind of wave. There's more attention to elected prosecutors, campaigns and elections than ever before. There are prosecutors who have a broader vision of their role in public safety than just convictions and investigations and sentencing. And I think that Ms. Fox is an example of that. I wonder if Mr. Hecht and Mr. Riedel, if you're seeing a change in expectations in prosecution in your jurisdictions, or do you feel it, as your membership and your leadership on national prosecution organizations, do you see that? And then, if so, what role is a more important or heightened role of the defense bar in meeting the expectations of the public?
I think the public perception when I first came into office was that our job was that we represented the police and that our job was to convict the people that were accused, and that we were paid by the severity of the sentence that defendants received. I think that there's a more nuanced perspective on the state of prosecution now, and I think a lot of what has changed things over the years has been the fact that I think people see us more now as problem solvers. They see us trying to keep kids out of the juvenile justice system by utilizing diversion programs that we have for that purpose, that we're more interested in facilitating kids getting to school and not being truant from school, so that they can become engaged in the broader community that they live in. They see problem-solving courts. Our substance abuse programs, our drug court programs have done a lot, I think, to change that perspective. And for people to see us trying to do things that help support the criminally accused, that help to provide them with tools or services that they need. We still have a long way to go in my jurisdiction as far as I'm concerned, but we're headed in the right direction with respect to that. I think that they've also seen us try to do more things that may be thinking outside the box to help people reintegrate back into the community when they have perhaps been incarcerated or been placed in a penal institution. And right now I'll probably be opposing a number of my colleagues in the prosecution bar because we have some legislation that's coming up before the legislature this session that is aimed at eliminating a lot of the employment collateral consequences of conviction. I think we have something like 707 bars or potential bars to certain jobs under our state statutes or regulations. And I know that a number of my colleagues around the state think that's the way it should be. I happen to think that we once had an ethos that talked about people paying their debt to society, and it seems to me that at some point that debt gets paid, and we need to facilitate them coming back into the community. And so I'm going to be talking to the legislature, to the Judiciary Committee in November about that, along with some other issues. And I think there's starting to be an awareness that just because an issue benefits one side of how people see the system operating, that people on the other side are going to naturally oppose it. When I go down to talk to the Interim Judiciary Committee, we're also going to be talking about interlock devices for DUI, for people convicted of DUI, for certain DUI offenses. We're also going to be talking about some legislation that I was asked, interestingly enough, by a good friend of mine who's a longtime prosecutor in the state of Wyoming and known as a pretty hard-nosed guy, and by Peter Neufeld of the Innocence Project, to get involved in some legislation that has to do with discredited or undermined forensic science and providing post-conviction relief in that area. And so I've gotten in and tried to be helpful to the draftsman of that particular piece of legislation to make it legislation that is effective and legislation that can actually work.
I think you do see some kind of a movement as far as what prosecutors in general believe. And I think we were seeing a movement from the federal side too, although I've always said it takes the feds probably a century or two to catch up with the local government and local prosecutors on what's going on. But I mean, I think we've started to see a trend, I think federally even, on how to prosecute, what kind of sanctions to request, how to treat drug users, things like that. Although apparently there's going to be a switch back to where it used to be. But from my standpoint as a elected prosecutor, I think so many times prosecutors worried about what their constituents they thought. They were thinking that their voters wanted people to go to jail. And I think, I mean, let's just face it, those of us, most of the prosecutors around the country are elected, want to be reelected. And so they're thinking about what are they going to look like. But I think you have to sell it, and that is to tell them and look them in the eye and be honest about it and say it is a public safety thing. Everybody's not going to stay in jail. Almost everybody that goes to jail is going to get out of jail, and they're going to be right back in the community. And we're talking about, the reentry programs, and that's why we're very involved with reentry programs. Not everybody should go to jail. And what I tell them is we've got to reserve the beds that we have because the state of Ohio and the prison system there, they're trying to let people out every day. I mean, they have a big barometer. When you do a fundraiser and you kind of mark up of how you're doing and how much you're making and bringing in, they have that, and when you go to the state penitentiary, to show how many they're releasing. So they want to keep releasing more and more and more because, why? Money, okay? In Ohio, they've just passed legislation that the local judges cannot sentence anyone to the state penitentiary for a fifth-degree felony, period. And that takes an effect in about a year. There were, I think, 8 counties selected, my county being one of them, that they said, you're going to start now. And so if you do want to sentence somebody, you judge, for that, we're going to charge you $75 a day. If you agree not to do this, not to send anyone to the state penitentiary, sentence them locally, so we're putting the financial burden on the local governments, then we will actually pay you money not to do that. So many times the finances drive this change too. But I just think as a real practical matter, as I've always said, not everybody deserves to go to jail. And that's why I love our diversion program, is because it makes a difference on helping people. And just like defense lawyers, judges, when you became a judge, I mean, yeah, you want to be a judge, but you want to do the right thing, but you want to help people. And that's what we do it for, is you really want to help victims of crime. You know, we shop, you know, I go to Walmart and walk into Walmart and people come up and say, you know, I just want you to know, you convicted me of such and such. And I said, well, that's good to hear. Did I handle the case? My background is a trial lawyer. I said, did I handle the case? Or did it say, well, one of your assistants did? Well, all right. But he said, you know what? I really want to thank you. He said, I got probation, and it really changed my life. I'm living over here about 3 miles from where I live. And he said, I live over there. I'm married. I started a relationship back with my children from a prior marriage. And he said, I've changed my life. That makes me feel good. I mean, it may sound wacky to some of you, but I mean, that makes me feel good. That makes me want to be a prosecutor. And likewise, when I see the victim who's had a 7-year-old who was raped, you know, by the next door neighbor, and she comes up and says, I want to thank you for what you did. You put him in the penitentiary. You gave, you know, some healing to my family. That makes me feel good too, because some people should go to jail. So I just think we are seeing, though, that we have to be specific and think about what do we want to use the penitentiaries for. And as you mentioned before, we have jail overcrowding. And so I said, I want to know everybody that's in our county jail. You know, we've got 1,500, 2,000 people. I want to know who's in our county, what have they done? We had people in there from one jurisdiction, I mean, for skateboarding. He was skateboarding. He was found guilty of skateboarding on a public whatever, a misdemeanor. We don't handle misdemeanors in my office, but a misdemeanor case. But he failed to pay the fine. Failed to pay the fine, and they put him in jail. Now, I think that's ridiculous. I mean, I think it's absurd. I said, you got to get rid of these people. I don't care what the judges think. Sorry, Judge, but you got to get rid of these people.
No offense taken by the judge.
You got to get rid of it. But likewise, you know, when I started a criminal non-support division in my office for people that just aren't paying their child support. We're not talking about alimony or spousal support, child support. I don't want to put them in jail. I want them to pay for their child, because that $25 a week means a lot to some people. However, what the civil court was doing is they're taking away their driver's license. And I told our support enforcement, I said, don't do that anymore. You know, because I'm not, when it comes here on our case, we're going to give it back to them.
And that
Because
speaks to
it makes no sense.
That speaks to the power of the prosecutor. And I think in saying we're not going to paper cases, we're not going to enforce certain laws that we think are unjust.